Look, I'm sorry, I'm not a lawyer. I'm a doctor. I've worked, on NIH-sponsored research and at Johns Hopkins. And I want to ask today not about profit, because look, I think the record speaks for itself. All the costs were covered by the procurement companies. Record speaks for itself. But I want, on Exhibit B2, the procurement company's brochure, it says that these are IRB certified consents. Exhibit C8, page 2 in the bottom says Biomed IRB approved. And in fact, I'm going to ask a legal question here because, IRB approval is very important in human research. And if you're looking at whether someone is out to make a profit, they're going to cut corners, they're going to save a dollar here or there. And so I'm going to ask a question about specifically this company called Biomed IRB. And I'm going to ask Madam Chair to enter into the record 2 letters from the Department of Health and Human Services regarding the company, one from March 29, 2012, the other from January 16, 2013. The March 29, 2012 letter actually is a letter to that company basically asking it to cease and desist from doing approvals or, in fact, anything being obtained under one of their approvals because of the shoddy work that this apparently one-room, single-owner IRB mill. That's the best way you can call it. You can you can go to their website, you can see their price list. I submitted things to an IRB. They guarantee that if you have it in by Tuesday before noon, you're actually going to have it before the IRB and approved that week, basically. But for $1,900 more, you can actually submit it after noon on Tuesday and have it approved that week. It's unbelievable. But what I want to ask is a specific legal question, because if, in fact, the company continued to obtain specimens under that IRB approval between March 29th and January 16, 2013, who's liable for that? If, in fact, when that IRB, when the FDA said you cannot obtain specimens, told the IRB that that's true. Mr. Lennon, who would be responsible for that?
I don't think I don't think I have a foundation to answer that question.
Let me ask you a question. Is it a valid question to ask? That, in fact, if the FDA had said you can't obtain tissue, you can't obtain anything under the IRB approvals that you've had until you've responded to us, and the letter came back almost a year later. If, in fact, a procurement company was obtaining tissue in that period of time, would that be a problem? Because Title 45 of the regulations, Part 46, make it pretty clear you need IRB approval. And, in fact, downstream federal research, where an IRB further downstream depended upon that information and that IRB to be accurate. In other words, if I was obtaining as a researcher tissue from this company, my IRB assumes that the previous IRB approval is actually valid, that in fact that company represents they have IRB approval. If they don't, is it valid to actually look downstream and see whether those IRBs were notified downstream, whether in fact those researchers were notified that this IRB approval in fact had been suspended by the FDA? Is that valid? Is that something we should look into? Mr. Norton, something we should look into?
I think that's a very valid question, frankly. And as I looked at the exhibits in preparation for this hearing, that was a question I had, is exactly what was the effect of and the date of and the integrity of the IRB approval process. As I understand Exhibit C15, it is a document that is being provided to the woman who's let me
go on
the abortion. So I think it's a valid, because essentially it's a false statement by the...
And let me go further to a false statement. On the videos, pretty clearly a doctor says, we modify the procedure to get better body parts. Pretty clearly. I mean, look, there's no doctoring going on here. This is, you look at it, and I urge anyone looking at this hearing, go look it up. The doctor says we alter it to preserve the calvarium so we don't crush the calvarium so we can actually get the amount of money we're going to charge for it. The federal regulations say you actually have to tell the patient if you're going to change a procedure. Now, I look at the consent forms, which is Exhibit C8, page 2. It says specifically your abortion procedure will not change in any way. We look at one of the consent forms that was actually entered into the record last time, which says that your procedure will not be changed anyway. If, in fact, the procedure is changed in any way, is that a violation of the IRB-approved consent, which is necessary for federal research dollars. It's actually necessary for any research to be conducted downstream. Is that a violation of that? If you in fact modified the procedure after the patient signed a consent that said procedure will not be modified?
Yes, I think that's also a violation of the statute itself.
Thank you very much.